live. I was not expecting to have to do this today. I was expecting there to be some sort of filing, but Babs decided to yote the case out of Washington this morning. Okay, so we are going to try to see if our friend I'm freaking Reckon. Hello, Reckon, if you are watching this. Um, okay, so that's up. Okay, so I'm having an issue with how slow this is loading. Okay, so I'm finally on. Let's see if it's been updated. Because I really don't want to have to go in and buy stuff with money that I currently don't have. Okay, so is this it? Yep. Okay, this is it. Okay, so we are going to download it so that I can just go into a PDF and make it big for you guys. Okay, so we have the PDF up. We are going to make my okay. So we have it. So this is the order granting defendant's motion to dismiss for lack of personal jurisdiction and denying defendant's motion for sanctions. So the last time I talked about this case, we talked about um we talked about the motion for sanctions. the defendant's the plaintiff's response to the defendant's motion for sanctions. And now we have a ruling. So, paragraph 1, introduction. This matter comes before the court on a motion to dismiss filed by defendants Katie Joy Poulsen, and without a crystal ball LLC. Okay, we are getting rid of the gum. On a motion for sanctions, also filed by defendants, the motion to dismiss, and on a motion for sanctions, also filed by defendants, the motion to dismiss was set forth on multiple grounds for dismissal, including lack of personal jurisdiction, lack of diversity jurisdiction, failure to join necessary parties, and failure to state a claim on which relief can be granted. Docket number 17, the motion for sanctions seeks an award for sanctions against plaintiff's counsel Michael Saltz under 28 U.S.C. section 1927 for alleged conduct related to the declaration of Lorianne Barnhart. Docket number 59, plaintiffs Tatiana Westbrook, James Westbrook, and Halo Beauty LLC opposed both motions, having reviewed the parties' briefs in support of and opposition to the motions and the relevant exhibits of the case law. Give me a second to post it. Come join me while I talk about the motion, the court yielding, the court dismissing the death of the Tati Westbrook death for hello. If anyone joins, I know I'm like midway through my stream at this point. I've been live for about 5 minutes. But hello. And today we are just sitting and we're going to discuss this motion in the case because we weren't expecting that today. I knew that I had a feeling, I didn't know because I don't talk to the lawyers in this case, any of them. but I had a feeling that something was going to be filed today. This morning when I got up, I'm like, oh, there's going to be something filed in the Tati Westbrook case. Let's wait for it. I would have went live a lot longer. A lot more earlier if I knew what I know now. Let's see. See how that looks when it comes up. Okay. Okay, so I need my webcam. We will learn how to use this and to stream. Well, I'll do a test stream next time, but so where were we? I think so we read that for alleged conduct related to the declaration of Lorraine Barnhart, docket 59, plaintiffs Tatiana Westbrook, James Westbrook, and the Halo Beauty Partners LLC plaintiffs oppose both motions, having reviewed the parties' briefs in support of in and in opposition to the motions, the relevant expedition exhibits of case law, and the rem, remainder of the relevant remainder of the record. The court grants the defendant's motion to dismiss for lack of personal jurisdiction and denies the defendant's motion for sanctions. The court the court's reasoning follows. Plaintiff Tatiana Westbrook is a self-described internet personality, celebrity, and influencer who critiques beauty products and posts for whatever reason, my AirPods decided to do something, and we are going to figure out why they're doing it. I'm also going to go in here and check to see. I have a notification in a server, so that's probably because I was added. We're going to move that piece of paper. Um, Let's get some. Plaintiff Tatiana Westbrook is a self-described internet personality, celebrity, and influencer who critiques beauty products and posts those critiques on social media platforms, including YouTube. So that's from complete paragraph docket, complete paragraph 10, docket number 1. She claims to have over 9 million followers on YouTube. Docket 1. Plaintiff Halo Beauty Partners Halo, a Nevada limited liability company, is a nutraceuticals company that produces products formulated to hair, skin, and nail health. Miss Westbrook founded her own and owns Halo with her husband, plaintiff James Westbrook, for purposes of the motion to the court. Takes true that the Westbrooks claims that they are and were, at the relevant times, domiciled in King County, Washington. Defendant Katie Joy Paulson is a resident of Minnesota. Her company, Defendant Without a Crystal Ball, is a Minnesota LLC. Paulson is an internet blogger and vlogger who makes, produce, and uploads drama and or tea videos. And internet posting on various internet-based platforms, including and not limited to her Twitter and YouTube. Defendants have estimated 135,000 YouTube followers. I wish I had 135,000 followers on YouTube. Both sides devote substantial effort to argue whether the Westbrooks are at all relevant times domiciled in Washington. Even plaintiffs deny, however, that plaintiff's domicile is relevant to the inquiry of whether personal jurisdiction exists over defendants, and furthermore, the court, as it must for purposes of the motion, takes plaintiff's allegations concerning the domicile as true. PLS OPPBC at 11. According to the complaint, starting in May 2019, defendants have uploaded to YouTube and Twitter dozens of videos targeting Miss Westbrook and Halo, designed to ruin Miss Westbrook's good name and reputation. ID paragraph 22. Those videos are presented as exposés covering a range of subjects, including a personal dispute between Miss Westbrook and a rival/fellow beauty celebrity, James Charles. Oh, and there we are. We're getting into bias again. That has nothing to do with this case. has nothing to do with this case. Has absolutely nothing to do with this case. Absolutely nothing. Why are we bringing up James Charles? Why? 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 Can someone tell me why we're bringing up James Charles? Oh, wait, there is no reason. Absolutely 100% is no reason, unequivocally, to bring up James Charles in this case. Because that's not what the complaint was alleging. The complaint alleges why you would make, what was it? Um 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 what does it say? Dozens? It was like dozens? And beauty celebrity, rival and fellow beauty celebrity James Charles, the safety and efficacy of Halo vitamins products, which Paulson has referred to as snake oil, which you just can't do. That's defamation. That right there is defamation per se. And they right there basically make it so that the judge and wherever they decide to refile, if they decide to refile, which is not something that we are so worried about, because I believe that they're currently sitting down talking with Tati and being like, "Hey Tati, where do you want to file this case?" And I believe that they're going to go and file a case in Minnesota, which is what KJ wanted to begin with. And personal and business of it, the personal and business history of the Westbrooks, including an alleged legal disputes between the business failures and the lawsuit filed in October 2020 in the Los Angeles Superior Court by plaintiff's business partner Clark Swanson against Halo Beauty Inc. LLC, a company affiliated with plaintiffs. See e.g. complete paragraph 29, complete 29, 28, 29, 32. Plaintiffs claim that these videos defendants have intentionally harassed and maligned plaintiffs and or otherwise maliciously portray them in a false light and sought to financially harm them. Defendants' videos have been published to and or are accessible by the general public and have been viewed hundreds of thousands, if not millions of times by plaintiffs of times ID paragraph 22 and 27. Plaintiffs have sued defendants for defamation, intentional infliction of emotional distress, and violations of the Washington Consumer Protection Act, among other emotional distress, or among other causes of action, seek $5 million in damages. No, not what it says. Absolutely not what it says. I don't understand how the judge is saying that when the judge has read the suit, because that's not what the suit says. In the prayer for relief in the suit, which I can pull up. So we're gonna go in and we're gonna grab the docket 1, docket 1, docket 1. Motion for sanctions. Where is it? Where is docket 1? Court docs. Bracken, where is it? Because you're the one that put this together. Declaration. Supportive motion for sanctions. So it's not there. So let's go on to Racken's Twitter. I don't know what you guys see. Give me a second. So we're going to go into media because it's going to pop up. I really wish that I had saved it. Like, wish I had gone in and saved all of this stuff so that I had it. Because if I had caught it, I had gone in and done it. I would have it. You know what? Let's just go with the fact that it's not on there because I don't see it. I This is riveting. I'm being riveting right now. So, if you're wondering why there's a messages thing right here, it's because I okay, we're just gonna go off the fact that that the prayer for relief never actually said $5 million. Well, that's Discord. That's my live stream for StreamYard. Okay, we are professionals here, people. And next time I go live and I'm breaking down documents, I should have, and I'm saying should, because I'm not sure if it's gonna work, but I get paid on Thursday, which means that next week I will have, for your consideration, a dual monitor setup for this computer so that I can live stream and break stuff down with a second monitor so I can separate the stream yards and stuff. So where were we? $5 million. Where did that claim? I am getting messages on Discord. What are people talking to me about? That'll also go up on. Okay, so 5 million in damages. See ID 50 through ID paragraph 50 through 114, plaintiff's civil cover sheet, docket number 1-1. Defendants moved to dismiss plaintiff's claims under Federal Rules Civil Procedure 12B for lack of personal jurisdiction because the court grants defendants motion to dismiss on these grounds. It does not reach defendants' remaining challenges to the complaint. General principles on a motion to dismiss. We are on page 4 of 13. How many people do I have in my stream? If you're here, just say hey in the chat. Just say hey in the chat. Say hey in the chat. I hit the X on that, hit the X on that. There we go. Oh, I already had StreamYards open. Okay. Um, so where are we at? Okay, so general principles for a motion to dismiss for the lack of personal jurisdiction. When a defendant moves to dismiss for lack of personal jurisdiction, the plaintiff hears the burden for demonst- demonstrating that jurisdiction was appropriate. Schwarzenegger versus Fred Fred Martin Fred Martin Motor Company. 374 F3D 797 800 Ninth Circuit Court 2004. So this right here is the case that they're using as case law. This is where it was filed and the year that it was filed. So this is the Ninth Circuit Court of Appeals for the United States Court of Appeals, I'm assuming, or Ninth Federal Circuit Court in 2004. All of a plaintiff's uncontroverted allegations are taken true, and the factual disputes are to be resolved in the plaintiff's favor. So when we say all things in a lawsuit are all things in a lawsuit are taken in favor of the non-moving party. What that means is that basically what that is all of Tati. So in this case, all of the plaintiffs. So all of Tati's uncontroverted allegations are taken as true, and the factual disputes are resolved in Tati's favor. For the just in the case for this case, just in that case for this case. That's not how it that's how it works in civil cases, in civil proceeding, in civil law. In the absence of an applicable federal law, jurisdiction is governed by a long-arm statute of the state in which the court sits. Glencore Grain Rotterdam BV versus. I'm gonna zoom in a little bit because I'm having a hard time reading that. Glencore Grain Rotterdam BV versus Shivnath Ray Harnenrin CO Company 28F dot 3D 101,114, 1123 Ninth Circuit 2002. Washington's long arm statute extends personal jurisdiction to the broadest reach of federal due process See RCW section 4.28.185 shoot v Carvel Carnival Cruise Lines 783.p dot page 2 d 78 7882 WN Washington dot Washington 2D 1989. To comply with the requirements of due process, a plaintiff must demonstrate that a non-resident defendant has established minimum contact with the forum and state that the exercise of personal jurisdiction comports with the minimal transitional nations of fair play and substantial justice. Burger King Corp. versus Ruseritz 471 US 962. Thank you, State of New York, for accepting my tax returns. Why do you have to? Why do you have to? Why do you have to? Why? Why do you have to interject in my live stream? Why? Hello, one person that's watching me. I just got interjected by personal things in my personal life. So where were we? Burger King Corporation versus Ruseritz 471 US 462 747 474 76 1985. Initial Sooo versus Washington 326 US 310, 316 1945. We're still on page 4. Jesus. Courts apply these 3-part tests to determine whether the non-resident defendant has requisite quantum of minimal contacts with forum state for the exercise of specific jurisdiction to be appropriate. The defendant has purposefully directed their activities towards the forum. The plaintiff's claims arise out of forum-related activities and the exercise of jurisdiction is reasonable. See Burger King Corp. 471 US at 472-67, Schwarzenegger 374 at F3D. And then the footnotes are: personal jurisdiction may be general or specific. Helicopters Nicomals D. Column SA versus Hall 466 US 408 415-416 1984. General jurisdiction requires that the defendant's contacts in the forum are continuous and systematic. See ID because plaintiffs here do not claim defendants are subject to this court's general jurisdiction. The court only considers the question of specific jurisdiction. We are now on page 5 of 13. And I need to take a sip. And maybe put one stick of gum in my mouth so I don't choke. At 8:02, defendants challenged the first prong of the minimal contact test, and denied that they purposely directed their activities towards Washington. Whether defendants' actions were purposefully directed at Washington State. 1. The effects of the tests under Calder are in subsequent wishes. The Ninth Circuit Court has recently acknowledged that the difficulty of analyzing personal jurisdiction in the context of an internet-based case when the individual in one state can cause serious harm anywhere in the world without leaving the comfort of their home. James V. Freeman, 2020, WL 7663439 at 9th Circuit, December 24th, 2020. So this is a 2020 case. This Juanes, I think it's Juanes versus Freeman is a Ninth Circuit Court that was is a Ninth Circuit Court case that was just decided on Christmas Eve of last year. Bayless, DJ, dissenting courts have sought to strike a fair balance between the interest of defendants who may have no intentional connection with the forum, and plaintiffs who have nevertheless experienced harm, all while maintaining a principled approach to the concept of jurisdiction rooted in due process. Even in this context, constantly and rapidly evolving technology, whether a defendant accused of an international tort such as defamation has purposefully directed its activities towards a forum significant to an established personal jurisdiction, is still governed by this effects test outlined nearly 40 years ago by the Supreme Court in Calder v. Jones, 465 U.S. 783, 1984. See Picote v. Weston 780F. 3D 1206, 1214, 9th Circuit, 2015. Under the test, courts are determined whether the defendant committed an intentional act expressly aimed at the forum state, causing harm that the defendant knows is likely to be suffered by the forum state. Marvis Photo Inc. versus Brand Tex Inc. 647F. 3D 1218, 1228, 9th Circuit 2011. Citations omitted. Apparently conceding prongs 1 and 3, defendants claim that plaintiffs have failed to establish the second element of the Calder's effects test, that defendants' conduct was especially aimed at Washington. In Calder, Shirley Jones, a California television and movie actress, brought a libel suit in California state court against a reporter and editor based on An article published in the National Enquirer, headquartered in Florida, 465 US at 784-86, in concluding that the defendant had. Oh, my AirPod died, and my AirPod case is absolutely. Oh, there it is. Okay. I'm gonna send this to someone too. I have it. Okay. Where was I? In concluding that the defendants had expressly aimed their conduct at California, the court noted the following factors were significant: that the defendant had reached out directly by telephone to sources in California, that the article concerned that the activities in the California resident and continued various facts that gave the article a California focus, that the National Enquirer sold 600,000 copies of the article in California out of a total nationwide circulation of approximately 5 million, almost twice as many as the next highest state, and that in contents that in the article. Hi, Tyler. Hi, Simon. Almost twice as many as the next highest state, and that the contents in the article are alleged to have caused an injury to the plaintiff's reputation in estimate in estimation of the California public, and specifically impunged the professionalism of the entertainer whose television career was centered in California. See Calder 465 US at 785, 788, Walden versus Fior 571 US 277, 278, 2014. Okay, so TLDR on the case of Tati Westbrook versus KJ and without a crystal ball. So KJ over back in 2019 posted a whole bunch of videos about Tati Westbrook and her husband James and Halo Beauty, and posted stuff about looking into Tati's life. Tati Westbrook sent 4 cease and desists from in the span of, I think it was 19 months, to KJ, telling her to stop and take down the videos. KJ did not comply with that cease and desist. So back in October, KJ got sued by Tati Westbrook after posting a video about Tati Westbrook getting sued by her business partner Clark Swanson of Halo Beauty. Statements that KJ made were that Tati and James were career criminals, that Tati sucked because of Bi Sister, and that Tati's vitamins from Halo Beauty were snake oil. So in November, the plaintiffs filed a motion the defendants filed a motion to dismiss, which I can pull up if it's in here. So here's the motion to dismiss, right? No, this is the motion for sanctions. Not what I needed. There was a motion to dismiss filed back in November. And then they filed. So after that, the plaintiffs file. Well, first, before the motion to dismiss, the KJ was deleting evidence. They filed a motion to preserve evidence and a motion, which in non-legal speak is a motion to not delete your shit. So don't delete your shit. That was settled via a stipulation agreement between the two sides that they would not be deleting evidence. Then they filed the motion to dismiss. Then after the motion to dismiss, they filed declarations for and against the motion to dismiss. Then somewhere around the middle of December, beginning of January, there was a whole bunch of threats of death and fun stuff like that. I need to go down. So, that happened. Then we get to 2 weeks ago when the plaintiff's attorney decided to file a motion for sanctions. Oh, wait, I forgot about the status conference. They filed a motion for a status conference, which was done back in the beginning of February. Yeah, beginning of February. Then 2 weeks ago, the defendants filed a motion for sanctions, a motion to speed up time, which cannot be brought in the state of Washington, which is where this court case is filed. And then a motion for and then there was another motion. Hold on. And a motion for sanctions and a motion to qualify, which does not exist. We were on. Okay, so I found myself. Good thing I had that highlighted. So a week and a half ago, the lawyer Saltz filed a motion against the motion for against the motion to qualify, and then like last week there was a motion against the motion for sanctions, and now we are here where the judge is now saying that no, we cannot. No, I will not give the lawyer for the plaintiffs sanctions, and also this case is dismissed. Get the fuck out of my courtroom. So right now I'm on page 5. Yeah, page 5. This is the court discussing defendants were not purposely where the defendants' actions were not purposely directed at the state of Washington. Courts have sought to strike a fair balance between interests of the defendants who may have no initial connection with a forum and plaintiffs who have nevertheless experienced harm while all maintaining principled approach to the concept of jurisdiction rooting in due process, even in this context of constantly and rapidly evolving technology where the defendant is accused of intentional tort such as defamation, has purposefully directed its activities towards the form sufficient to establish the personal jurisdiction is still governed by the effects test outlined nearly 40 years ago in the Supreme Court case of Calder. Oh, I've already read this. Okay. So they just, went over the effects test that was put out in Calder back in 1984, back 45 years ago. Which is, do we have sufficient sufficient ability in the form and, intentional tort that aimed at the person's knowing resident of the forum, state Juanes 2020. So this is a 2020 case right here. So Walden versus Fior. Juanes. So this is a 2020 case. Mere injury to a forum resident is not sufficient connection to the forum. The Walden court noted that the proper question is not where the plaintiff experienced a particular injury or effect, but whether it's not clear in the case law what distinction, if any, is intended between the phrases purposefully directed and expressly aimed, but for the purposes of this case, because defendants have not challenged the first and third prongs, the effects test effectively collapses into the first prong of the minimal contact test. So does anyone have any questions at all, at large, or anything about this case? While I take a sip of my Gatorade. This is not sponsored by Gatorade. I just like Gatorade. Okay. You're going to see my streaming service. So I can show that. So the question is, who are the people involved? So the people involved in this case are, I can go back to the first page, Tatiana Westbrook and an individual, James Westbrook, an individual, Halo Partners Halo Beauty Partners LLC, a Nevada limited liability company, which are the plaintiffs in this case, versus Katie Joy Paulson, an individual without a crystal ball, an LLC, a minute a LLC, a Minnesota limited liability company, and does 1 through 100 inclusive. So, and that's the defendants. And a doe is anyone that, may or may not be involved in the case. Yeah, that's the abridged version. It's over from I think it's over like 400 videos and like 800 tweets and 765 hours of content that has to be watched by all of the lawyers involved. Hey Tyler, are you still here or did you close out? So we're past that. Burger King Court, preparation, personal jurisdiction. We're at page 6, about midway down. Or no, not even midway down. We're almost at the end of the page. Since closure, courts have weighed in similar factors connecting the defendants with the form, tempered by the recent admission in Walden v. 4, a case that a unanimous Supreme Court expressly rejected. The view of Calder's effect test is satisfied merely by the defendant's commission of an intentional tort aimed that was her claim, which is unequivocally untrue. The reason why this case is being dismissed is because there's not enough evidence to tie the defendant to the form. So there's not enough personal jurisdiction. The court cannot express personal jurisdiction over KJ because there is not enough evidence that the form has been affected in a certain way. Defendants conduct connect. So the proper question is not where the plaintiffs experienced a particular injury, or effect, but whether the defendant's conduct connects them to the form in a meaningful way. So this right here is a 12B2 motion for a 12B2 motion to dismiss, which means it is not 6. It's just not. There's not a proper amount of information to tie the court to have jurisdiction over a specific person. So, like, if this would be like me going and suing someone in California for a video they made against me, but them not having any video. Or no, this would be like me getting sued by someone in California, but not having any viewers in California because I said something in a video about someone. and me filing a motion to dismiss that case because literally they can't bring it. It cannot be brought. That cannot be brought. That cannot be brought. So don't try it. 571 US at 290. As noted above, in the context of the internet-based conducted in particular courts have struggled with the question on whether a torturous conduct on a nationally accessible website is expressly aimed at any or all of the form in which the website can be viewed and have required something more than maintenance of a passive website available anywhere with an internet connection. Mavericks Photo 647 F3D at 1229. The Ninth Circuit has found jurisdiction where a defendant is continuously and deliberately exploited the forum state market for its website and a substantial number of hits. I'm neutral. I'm just reporting on it as a journalist. I'm neutral. I don't have a side. Secretly, I really love what the plaintiff's lawyer in this case is doing because he's very shady, which is why me and all of the fans of Emily D. Baker have named him Saltsy. Because he's salty, and his name is Salts, and we love him for that. Hi, Michael Saltz, if you're seeing this. I'm sure you're seeing this. I'm sure that you're going to be seeing this at some point because I'm reporting on this. After this live stream, Simon, I can send you some research. I can send you some other, sources that it can actually break this down better than I can because I'm not a lawyer. I just want to report on this. I just want to have, something behind me. And if anyone wants to motion for anything, you can motion in the chat. And I will either sustain it or it will be overruled. Where was I? What line was I on? Does anyone in the chat remember what line I was on? Because I literally lost my I lost my I lost my spot. What line was I on? Then okay, I'm just gonna start at line 5. Required something more than maintenance of a passive website available anywhere with an internet connection. Mavericks Photo, 647 F.3D at 1229. The Ninth Circuit Court has found jurisdiction where a defendant continuously and deliberately exploited the forum state market for its website, and a substantial number of hits to the defendant's website came from the forum Mavericks Photo, 647.f3d at 12:30. Keemstar's going to have videos about this because Keemstar was in Emily D. Baker's YouTube channel. In her stream today for 2.5 hours. I was there for 2.5 hours. Hold on. I'm going to put in the chat. Okay, we are not defaming we are not saying fuck Keemstar in my chat. I will not allow that, Simon. Simon, stop, or I'm going to put you in timeout. I don't have anyone moderating my chat. But I will put you in timeout. Where was I? Okay, I was in 9. It has declined to exercise. Sorry, Simon. You were put in timeout. Because you're distracting me. It has declined to exercise jurisdiction, however, even where almost 20% of the defendant's total circulation was located in the forum where plaintiffs did not establish that the defendant expressly aimed at the forum or tailored the website to attract forum-specific traffic. AMA Multimedia LLC versus Onet 790 F3D 1201, 1211, 9th Circuit 2020. Whether the defendant's suit-related conduct was expressly aimed at Washington, the case demonstrates that the ultimate question is when the defendants expressly aim their suit-related conduct at a forum state is intensely fact-specific. See attachment Corp versus Pub Health TR of Miami-Dade County, Florida, 686 F sup dot 2D 1140, 1147 WD Washington 2010. One clear import of the Ninth Circuit's case law record regarding express aiming at the district court's inquiry on the score must be grounded squarely in the fact that must be grounded squarely in the fact of particular cases. After examining defendants' connections with Washington state courts, conclude The court concludes that the defendant's contact in this case are the kind of random, fortuitous, or at- at- attenuated contacts with the forum state that Walden contained courts against relying on. See Burger King Corp. 471 U.S. at 475. See also example Axum Foods Inc. versus Arsham Intel Corp. Intel Inc. Intelligence Inc. 874 F. 3D 1064. And we are on page 8. Page 8 of this damn motion. Hey, Simon. If you're still here, text me on Discord. I'll just pull Discord up for a second. Or post in the chat, I don't know. Okay, so here's where we get into source content. (1068) Ninth Circuit, 2017. The connections alleged include sources for the content. Plaintiffs allege that defendants searched through and relied upon Washington sources for their information. PLS OPPBR at 11-12. The evidence demonstrates, however, that Poston concluded several different searches using general internet search engines looking all over the place, wherever. DL's declaration of Tati, everywhere. Simon, if you're still in the stream, it is against terms of service. And no, he's not, because he's reporting on the news. And he won a defamation case. Keemstar only reports on the news. He's changed in the last few years. That was like 4 or 5 years ago. He's changed. Even in the last 3 months, he's changed. I mean, he just won a lawsuit against Romeo Lacoste and took Romeo Lacoste's play button. The evidence demonstrates, however, that Paulson conducted several different searches using general internet search engines, looking all over the place, everywhere. Declaration of Tati Westbrook, paragraph 11, quoting May 31st, 2019, quoting a May 31st, 2019 video. Sephora arrived at my house and I'll answer questions too. Paulson did a regular very basic background check, and also noted you can actually go state to state and try to pull up some stuff as well. Plaintiffs argue that Paulson must have used Washington-specific websites in her research to reasonable inference from content of her videos. However, it is clear that she likely used state-specific websites from multiple other states as well. Example, paragraph 12, citing a June 2nd, 2019 video, The Past James and Tati Don't Want You to Know. The past video, Paulson stating, all of this came from court records from Hawaii, California, South Carolina, North Carolina, Washington State, and Georgia. All this is public record. Unlike in Calder, there is no allegations that defendants reached out directly or indirectly to any resident of Washington for information for the video. Plaintiffs claim that defendants rely upon Washington source is significantly overstated. So that's what this suit's about, is claiming things that not necessarily are completely true in videos that she posted, and in a Pathos article, and in the motion to dismiss, they stated evidence from these videos, or in the suit they stated motions for these videos, and then in the motion to dismiss, KJ put in in a link for a Trisha Paytas video saying that Tati Westbrook sucks, putting in Jeffree Star's I'm never doing this again, put in Bye Sister, put in taking putting in breaking my silence, put in put in a link to fucking put in a link to her house, in California. Put in a Keemstar video. Put in a link to knowyourmeme.com about what a Dramageddon is. Can we drop? Okay, I'm asking you as the court of this YouTube channel to cease and desist from the talking of Keemstar in any professional capacity with me at this point in time. If you do not follow my command, I will ask you to leave. Understand? Simon, do you understand? Because I know you are still watching the stream and you can hear me. I'm exiting out of your messages on Snapchat for the moment. Does anyone have any questions about the case and what I'm breaking down right now? Or is everyone completely understood? Like, does everyone completely understand? Also, unlike the article in Calder, which was focused on Jones' activities in the forum, defendants' videos do not refer to any substantive way to activities conducted in Washington. Plaintiffs' preferred example of defendants' reference to Washington are brief, isolated, and incidental. See Tatiana Westbrook declaration, paragraph 12, citing the past video at 13 minutes. Tati grew up in Washington, and her mother actually was her talent agent. Tati and her family moved around a lot. Other than the brief reference Paulson makes to Miss Westbrook's small tax warrant in 2003 in Washington lasting mere seconds, of the hours and hours of videos at issue, the court was unable to identify explicit references to Washington that may arguably expunge im- impinge the Westbrook's reputation. See Tati Westbrook Declaration 11, paragraph 11 and 12, citing the past video at 15:30. Critically, almost none of the few Washington references in defendant's video are connected to underlying defamation claims in this case. Instead, the majority of defendants' alleged offending content concerns events and subjects such as Miss Westbrook's feud with James Charles. Why are we bringing up James Charles again? I don't remember this. I sat through Emily's breakdown and I don't remember this. And the Los Angeles lawsuit Clark Swanson filed against Halo that took place in California are virtually online. Defendants none of Miss Westbrook's YouTube videos are a frequent topic of defendants' videos was apparently filmed in Washington or even concerns activities that took place in Washington. This is in contrast to the situation in Calder, where the court reviewed the various facts that gave the article a California focus, concluded that the California is the focal point of the story. Calder 465 at 789, Mavericks Photo Inc., 647 F.3D at 12:30, noting defendants operated a very popular website with a specific focus on a California-centered celebrity and entertainment and the entertainment industries. How long have I been live? I feel like I have been live for over an hour. It should tell me how long I have been live for an hour, 38 minutes, and 25 seconds. Jeez. It's taken me an hour just to break this stuff down. I guess that is. I'm on page 9. Activities directed at a large number of citizens of the forum. So I have 4 pages. I have little over 3 pages left. Calder and its most recent progeny also indicates that a plaintiff must demonstrate that the offending content both reached a large number of forum state residents and was intentionally targeted at the forum. In Calder, the reputation-based effects would not have occurred but for the fact that the defendant wrote an article in publication in California that was read by a large number of California citizens. Walden 571 U.S. at 288, emphasis added. Also see Keaton v. Hustler Mag Inc. 465 U.S. 770, 781 1984. Finding specific jurisdiction appropriate in state where a substantial number of copies, 10,000 to 15,000 per month, are regularly sold and distributed. As more recent cases dealing with the internet-based injury established, it is not enough to that a defendant's content is merely accessible by residents of a forum. Not all material placed on the internet is solely based by virtue of its universal accessibility expressly aimed at every state in which it is accused. Mavericks Photo Inc. 647 F.3D at 1231, where the plaintiff does not identify any evidence with the defendant specifically targeted at or solicits form state viewers from the form state residents' ability to view defendants' online content alone is not enough to demonstrate express aiming. E. Casanovo v. Morrow, 2021. So that's a extremely recent case. WL 682058 at 3, dated November 22nd. No, dated DNev February 22nd, 2021, citing Medas v. Premium Nutraceuticals LLC 715F dot appendix 662.663 or comma 663 9th Circuit 2018 Hanson Music LLC versus eToro US LLC 2020 Washington WL 8455 111 at 9 CD Cal December 17th 2020. Plaintiffs do not present any evidence to show defendant's website has specifically focused on California or sustainable California user base. Plaintiffs proffers no evidence to show the defendant's post and profits from California specific advertisements on its website. Furthermore, the online stock and commodities trading market cannot reasonably be considered a California-centered industry, unlike the celebrity gossip industry described in Mavericks Photo Inc. Arguably resolves around Hollywood, California. The industry to its defendant belongs is not specific enough or not specific to one geographic area. The court takes true traces Barefoone's claims that the defendant's viewership includes residents of Washington, but the factor alone is insignificant to appear to support to their bid of jurisdiction. We have 2 pages left. Well, 1, 2. We have 2 pages left, and then the conclusion. 11. Where does 11 start? Get me to page 11. 1. PLS OPP.BR at 4. In support of their claim the jurisdiction lies in Washington, plaintiffs have submitted 1 declaration of 2 Washington residents who viewed defendant's video and based thereon decided not to buy plaintiff's products, and 2 declarations of one of the defendants and the declaration of one of the defendants, fiercest and loyalist fans of the Washington's resident of a of fans, a Washington resident who subscribed to defendant's YouTube channel during the time period that Ms. Paulson published numerous videos and other content maligning plaintiffs in this case. See DLC of Declaration of Mary Strom, Hope Walker, docket numbers 27 through 4, and docket 5, and Declaration of Kim Fulmer, P11, page 11, Declaration of Lorianne Barnhart, docket number 38-1, paragraph 5, even crediting the testimony of those 3 witnesses, the declaration of the 3 viewers in Washington, out of the alleged hundreds of thousands, if not millions, of times that defendants' videos have been viewed, only highlight a vast discrepancy between this case and the 600,000 California readers of Calder complaint. Paragraph 26 and 27. Also see Maverick Photo Inc. 647 F.3D at 12:30. Jurisdiction existed because of a substantial number of hits to defendant's website. Hits to defendant's website came from California resident Emphasis AMA Multimedia LLC 970.F3D at 12:11. Court lacked jurisdiction, even though 20% of the... am I still on page? Okay, good. Because I feel like I'm reading the same thing over and over and over and over and over again. Of the defendant's audience lived in the forum. Significantly, plaintiffs have proffered that no allegations, for example, Washington-specific marketing or advertising from which one could conclude that the defendants targeted Washington as opposed to a wider audience. Generally, the court finds that the plaintiffs have failed to demonstrate defendants expressly aimed their video content at Washington, thus have not shown that the defendants purposely directed their actions towards Washington state. Therefore, the court concludes that Washington is the improper form, that the court lacks personal jurisdiction over defendants. So that right there just stated, Tati, I don't fucking care. Get the fuck out. Get out. Get out. Leave. Bye. Now, we go on to page 12. This is quick. This is going to be quick. So, defendants' motion for sanctions. Defendants have filed a motion for seeking sanctions against plaintiff's counsel Michael Saltz, extensionally accusing him of harassing and intimidating third-party witness for Lorianne Barnhart for both and of suborning and committing perjury. Motion for sanctions, docket number 59. Defendants rely on 28 U.S.C. 1927, which provides that the court may order any attorney, other person admitted to conduct cases whose multiplies the proceedings in any case unreasonably or and vexatiously to satisfy personally the excess costs, expenses, and attorney fees reasonably incurred because of such conduct were ordered. These sanctions must be accompanied by a finding that the sanctioned attorney acted recklessly or in bad faith or committed intentional misconduct. Barned v. City of Tacoma, 664 F2D 3369, 1343, 9th Circuit, 1982. Also see Keegan, Management Company, 2nd 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 Circuit, 1982. Also see Keegan, Management Company, Secretary Litgid. Also see in reference Keegan Management Company's section litigating 78F.3D 431, 436, 9th Circuit, 1997. Bad faith is present when an attorney knowingly or recklessly raises frivolous arguments or argues a murderous claim for proposing harassing an opponent. Quoting Estate versus Blas v. Winkler, 792F.2D, 558, 560, 9th Circuit, 1986. The court declines to rule on the defendant's motion for sanctions for several reasons. First, misconduct alleges the misconduct alleged is serious and if proven could expose us to sanctions up to including disbarment. Given the gravity of the potential consequences, because the defendant's allegations both convoluted and avidly disputed, the court could not rule on the motion without an extensive evidentiary hearing. Furthermore, because of Barnhart Declaration, it is not material to the court's ruling on jurisdiction. The integrity of these proceedings is not implicated to the extent that the defendants contend, and while the court acknowledged this, it has the discretion to rule on the motion. The fact that this case is being dismissed means the court's supervision of the proceedings is no longer required. In summary, the court declines to devote its resources to investigating the activities of a California attorney not licensed in Washington in a case that is being dismissed. The motion for sanctions, therefore, is denied without prejudice. And in conclusion, for the foregoing reasons, the court grants defendant's motion to dismiss. The motion for sanctions is denied without prejudice. This case is dismissed without prejudice. Dated this 15th day of March, signed by Barbara Jacobs Rothstein, U.S. District Court Judge for the 9th District of the Court in Washington. So we have finished reading the declaration. This case has been dismissed out of Washington as of early this morning. It has taken me this long to finish this. It has been 13 pages, and I have had some tangents, and I have gotten off track. It has been almost 2 hours. Does anyone have any questions? Any questions? Any questions from anyone? Anyone have any questions? Are there any questions? Or can I just leave? Hello, anyone? Anyone? Hello, Bald. Bald? Hello. Hi. Hi, any questions? Any questions from the one person that just entered the chat? I can scroll up a little bit because this might answer your question. Okay, so if there's no questions, if there are truly no questions, I'm gonna sign off. I'm gonna ask everyone in the chat to do the YouTube things, like, comment, subscribe, share with your friends. In my opinion, I don't think Babs should have dismissed the case because, you know, there are enough, in my opinion. I just wanted to see, Salt and Brown fight some more. But if that's all that we have for tonight, I'd like to thank everyone who came. If you want any more stuff, if you want anything, any more information on this case, you can go watch youtube.com. You can go watch some videos off of Emily D. Baker. I will post her YouTube channel in the chat. That's my YouTube channel. So, and with that being said, go check out that YouTube channel that I just posted in the chat, and we are going to say goodbye.